Good afternoon and welcome. My name is Dayna Bowen Matthew, and I have the pleasure and the privilege of being the dean here at GW Law School. I always say my pronouns are she, her, and hers, and I'm delighted to welcome you to the George Washington University Law School for the 2023 Brand-Manatt Lecture. This is a wonderful day in the life of this law school. And I'm going to show you how old I am by doing this a little bit. I want to first begin by thanking the Manatt and Brand families for establishing this flagship lecture series that advances the study of international law. We are extremely proud and truly blessed to count the late Joe Brand and the late Ambassador Charles Manatt among our distinguished alumni. I'm also thrilled to share with you that Kathy Manatt is here. Kathy?
She may not have made it.
Oh, she hasn't made it yet. All right, when she comes, I will welcome her. She's the wife of the late Ambassador Manatt, and we will welcome her when she arrives. I'd like to extend a warm welcome to Wes and Barbara Burnett, who generously endowed our deanship in international and comparative law and are here with us today. Thank you so much, and thank you for being here. The Brand-Manatt Lecture was established in 2016, and it brings leading public figures and scholars to the law school to discuss the pressing issues of our time, particularly in international law. Mr. Brand, who graduated from our law school in 1963, was a partner at the law firm of Squire Patton Boggs and a trustee of the George Washington University. Mr. Manatt, who graduated from our law school in 1962, was also the founder of the Manatt, Phelps, and Phillips firm and the U.S. ambassador to the Dominican Republic. He was also chair of the Democratic National Committee. Now, the GW law community was saddened to learn, of course, of the passing of Mr. Brand in late 2022. While both Mr. Brand and Mr. Manatt are no longer here with us in person, their spirit and their dedication to the law school and to international law lives on here at GW Law in so many ways, including through this lecture, the Brand-Manatt Lecture. I would like to begin by extending a very warm welcome to our distinguished keynote speaker, our distinguished scholar, leader, activist in human rights, lawyer, Philippe Sands, KC, a professor of law at the University College of London and director of the Center on International Courts and Tribunals. Thank you for addressing us on the topic of the Lost Colony, Law and Decolonization from Chagos to the Ukraine. Our illustrious speaker is a marvel in international law. He litigates cases before the International Court of Justice, sits as an international arbiter, and is the author of 17 books on international law, spanning on topics ranging from crimes against humanity, genocide, colonization, colonialism, and many other pressing topics in the field. Many thanks to you, Mr. Sands. For joining us today, we look forward with great anticipation to your lecture, and we are thrilled to have you here at GW Law. Before turning the podium over to my colleague, Professor Sean Murphy, the Manatt Professor of International Law, who will formally introduce our keynote speaker, I'd like to take a moment to recognize a few other distinguished people whose work is on full display today. First, I extend my thanks to the International and Comparative Law Program for organizing this outstanding program. And it was put together by Professor Sean Murphy, Professor Ralph Steinhardt, Dean Rosa Solario, Leah Salabrio, and Yinsi Dai. Thank you to all of you. And let me not forget to thank also Deb Gales for her great law school events planning and adding her special touch of warmth to today's occasion. Finally, I'd like to extend my deepest gratitude to the event co-sponsors, the American Society of International Law, the ABA section of International Law, and the International Law Student Association. It is now my great pleasure and honor to turn the podium over to Professor Sean Murphy and to thank and welcome you for being with us here today.
So thank you very much, Dean Matthew, for those warm, welcoming remarks, and I'll extend my welcome to everyone as well. Before I introduce our speaker, we're going to have a brief reflection from Professor Ralph Steinhardt with respect to the passing of our distinguished alum, Joe Brand.
Thank you, Sean. Hello, everyone. It is an honor for me to honor Joe Brand. And it's an honor cubed to do so on a stage with two of the leading international lawyers in the world, Philippe Sands and Sean Murphy, both of whom he admired profoundly. And to connect again with the family of Joe's dear friend, Brand-Manatt, this endowed lectureship in their name is a concrete manifestation of two friends' love for the field of international law, for this law school, and for each other, frankly. It is a testament to the power of a decades-long friendship that started in these halls. I met Joe Brand when I was a second-year law student back in the late Jurassic era, interviewing at the Patton Boggs law firm for a summer position. And I will never forget that Joe had art on his walls. Not his degrees, not pictures of himself with famous people, not certificates of appreciation or front page stories about him and his work. Art, as in the Washington Color School. He also had no desk in his office, which I thought at the time was not only strange, but probably the most radical form of lawyering I had ever encountered. It turns out that not having a desk was not Joe's elegant rebellion against orthodoxy. It's just that his furniture hadn't arrived yet. And it took some years being in his orbit before I realized just how radical and unorthodox and professional his work really was. I counted him a friend and a mentor for over 5 decades. Even though we never fully bonded over his love of Tchaikovsky or horseback riding or business trips to Russia, which I did not and do not do, I marveled at how fast he would finish a meal, which he attributed to going to a boys' school. But it also explains how he was able to finish in record time and then order a dessert for me, right? Telling the waiter what he thought I should have for dessert. On the other hand, what I most remember and that is most emblematic this afternoon is his generosity. It's his generosity that is vital in my memory. I've seen him give a tip that was greater than the cost of the meal, sometimes by multiples. I've seen him give the collected works of Charles Dickens to a newborn, and then I have watched that newborn grow and be an English major and a writer herself and my daughter. I've seen him give away his clients to his younger partners. I've seen him serve this law school for decades, teaching and hiring its students, investing in its future, especially the international law program, helping to pick and then guide its leaders and celebrating its accomplishments, helping to see and correct, let's call them missed opportunities when he saw that happening. I close with this. I hold in my hand War and Peace. It's not that War and Peace. You can tell because it's only this thick. On the other hand, this is only the first of 3 volumes. This is a book that is very much connected to his values and to his generosity. And it is very much connected to our splendid event this afternoon. Some years ago, Joe Brand gave a 1725 edition of Hugo Grotius's towering work on the law of war and peace to the GW Law Library. This 300-year-old book was published 95 years after Grotius wrote what many consider the first definitive work of international law in Europe, despite its debt to earlier scholars. Grotius wrote at a time that was considerably more violent and chaotic than our own, and he offered a systemic plea for the spirit of law in international relations. And on the way, he offered a framework for sovereignty that was defined, protected, and limited by the law, all for the good of human beings that were touched by it. This stands in for his presence. It stands in for his love of learning, his love of writing, his love of books. It doesn't stand in for his love of poetry, which I'm sorry is hard to convey. The tougher, the better, as far as poetry was concerned, especially when it came to the work of Seamus Heaney, May Sarton, William Butler Yeats, Philip Larkin, Stanley Kunitz. But I have to tell you, right now, I hear his ghost in the back of the room saying loudly, "For the love of God, Ralph, sit down." And let us hear from the real stars of the show. And he's right, of course. So let me pass this to my distinguished colleague and friend, Professor Sean Murphy, to introduce our speaker.
Well, thank you, Ralph, very much for that very moving tribute to Joe Brand, a very distinguished alumnus and friend of the law school. Thank you as well for letting me handle this book. The library doesn't let me check it out or hold it, so this is a treat. So it is my pleasure to introduce our Brand-Manatt lecturer for 2023, Professor Philippe Sands. I think it's fair to say that Professor Sands has trod on three principal paths in the course of his professional career. First, as the dean indicated, he is currently a professor of law at University College London, having previously held academic positions at Cambridge University, which is when I first met him, King's College London, and the University of London School of Oriental and African Studies. He's also been a visiting professor at other universities, Harvard University, New York University. And as an academic, he has published widely in the field of international law with particular interest in subjects such as international environmental law, international organizations, and international dispute settlement. Second, Professor Sands is a practicing barrister, long associated with Matrix Chambers in London, but now at Chambers of 11 KBW. As a practicing lawyer, he has appeared before the International Court of Justice and several other international courts and tribunals, and has sat as a international arbitrator. This afternoon, I believe his presentation is going to talk mostly about his representation of Mauritius before international tribunals, but he has acted in many of the seminal cases of the past 25 years, far too many for me to list out. Third, he's a beautiful writer outside the purely academic domain, one who has helped bring the field of international law to a popular readership. Perhaps his best known book in this regard is East-West Street, On the Origins of Crimes Against Humanity and Genocide, which was published in 2016. In that regard, perhaps I should note that today is Holocaust Remembrance Day, also known as Yom HaShoah, Israel's day for commemorating the approximately 6 million Jews murdered by Nazi Germany and its collaborators. So this afternoon, we will hear from Professor Sands about his latest book. As the dean indicated, it's entitled The Lost Colony, A Tale of Exile, Justice, and Britain's Colonial Legacy, published in 2022, I think in the UK, but perhaps this year in the United States. And I believe it will include some reflections on that book's pertinence to contemporary events, notably Russia's invasion of Ukraine. Please join me in welcoming Professor Philippe Sands.
Thank you so much, Sean. Thank you, Dean. Thank you, Professor Steinhardt. And my thanks also to those who sponsored this lecture and made it possible for me to return to a university that I've come to know pretty well over the years, and it's incredibly nice to be back. I do also add my own sense of condolence to the passing of Joseph Brandt, who I didn't know, and also to his colleague, Ambassador Manatt. As I said, I've had the happiness of knowing this wonderful law school for more than 3 decades, and it's incredibly nice to be back, and to do so walking in the footsteps of some very lovely previous lecturers in this series. The invitation, as Sean intimates, may have been generated in part by my work on the individual and the group, on crimes against humanity and genocide, academic writings, litigation, books, and podcasts, from East-West Street to the Rat Line, exploring Nuremberg, that revolutionary moment when, for the first time in human history, the country's leaders were held to account before an international court. The idea that no country or person is above the law. A moment that heralded what was, in 1945, a new approach to international relations and to rules. Matters of justice are at the heart of these books, and a third one in the series is on the way right now with a very Chilean flavour. Think Augusto Pinochet, Walter Ralph, Bruce Chatwin, Punta Arenas, tinned crabs, and mass murder. Matters of myth and impunity are at the heart of the next book. And it's always about how the personal melds with the political, and the central theme, the role that individuals can play. But this evening, I want to tell another story. It too is about responsibility and silence, memory and identity. But it lies somewhat closer to home in terms of space and time, although I suspect very few of you in this room know about it. For it seems in this country, and in the country where I live mostly, which is Britain, we are very easily distracted by horrors that are perpetrated by others. And we find it less comfortable to engage with our own pasts, with our own colonizing instincts, and with our own propensity to treat the other as somehow lesser. This tale is about a place called Chagos. It's an archipelago scattered across a vast swathe of the Indian Ocean. And I want to be clear at the outset, I am not at all independent in telling this story. For 13 years, I've served as counsel to Mauritius, a small African country, in a case about a place that London and Washington like to call the British Indian Ocean Territory. The British government's website jauntily describes this place as an archipelago of 58 islands covering 640,000 square kilometres of ocean. It is a British overseas territory administered from London, located approximately halfway between East Africa and Indonesia. Access to the area is totally restricted, the government website tells you, although if you are the owner of a private yacht, you are directed to another website to apply for mooring permits. The official website says nothing about the past. The fact that it was the last colony that was ever created by Britain, and that today it is still just about Britain's last colony in Africa. Nor does the website say anything about the fact that it is being illegally occupied, that many years ago, its former residents, black and descendants of enslaved people, were forcibly deported, and they wish to return. Britain sort of hangs on, issuing colourful, beautiful stamps like the Royal Angelfish stamp, the portrait of the Queen. To tell this story, I think it's really important to begin with a first-hand account of what passed. I'm making a reference to a short video that was played in the Great Hall of Justice in The Hague at the International Court on the morning of September the 3rd, 2018. It was the witness statement delivered by a lady called Lisby Elise. Please remember her name. And in that statement, in 3 minutes and 47 seconds, she described to the court what happened to her on a day in April 1973, when she was told that she must leave the next day. And she has described to the court how she wanted, ever since that day, to be able to return. I came to know Lisby Elise several years ago, and we've stayed in very close contact ever since. Her story resonated for me because it reminded me of other deportations which were, in a distant sort of way, more familiar. Of my two great-grandmothers, of whom I wrote in East-West Street, but of course never knew, who were transported from Vienna in July 1942 to a place called Treblinka. Like these two great-grandmothers, Lisby Elysée was allowed to leave with just a single suitcase. After that day in court together back in September 2018, we stood together outside the Peace Palace, and she asked me a single question. Why, Philippe, has it taken so very long to get to The Hague? I didn't have much of an answer to give her, except that justice is a long game. The origins of Lisby Elysée's story and her long journey go back to a few years before her birth. Saturday, August the 9th, 1941, the United States ship Augusta moored in Little Placentia Sound off the coast of Newfoundland, a British colony. On board that vessel sit Franklin Delano Roosevelt and Winston Churchill, quarrelling about the future of the British Empire. The President tells the Prime Minister that both countries must work together to end a backward colonial policy and support an idea that will come to be known as the right of self-determination. Words matter. The two men signed something called the Atlantic Charter, in which they expressed their hopes for a better world. Churchill didn't realise he had walked into a trap. The document committed the two countries to respect the right of all peoples to choose the form of government under which they will live. They reflected Roosevelt's hope that the colonised would obtain their own nation-state. Churchill read the document completely different. He would tell the House of Commons a few weeks later in London that the words in the Atlantic Charter, self-determination and all this stuff, were only for those who lived under the Nazi yoke. They were not intended for people who lived in British colonies. That reading was not shared elsewhere in the world. In Africa, a young man called Nelson Mandela saw the document reported in a newspaper, clipped it, and kept it in the breast pocket of his jacket for decades. In his view, and he writes about it in his autobiography, the words in the Atlantic Charter heralded a new era, one of full citizenship and an end to discriminatory legislation. As with so many things in international law, one thing sort of led to another. The ideas in the Atlantic Charter influenced the drafting of the United Nations Charter, and in the summer of 1945, change came more broadly. Decolonization was the hottest subject in town, wrote Ralph Bunche, the State Department's lead negotiator on colonial issues, as decolonization became an aim of the new charter. Article 1 of the United Nations Charter committed countries to a wholly new idea in international law, the principle of self-determination of peoples. And the language was pretty revolutionary in international legal terms. Although it didn't define the term, the compromise of that failure offered a nod to the British and the French. And so began, in the modern sense, the process that we've come to know as decolonization. For Britain, it started with India, a great deal of bloodshed, and it went on and on and on. But large parts of Africa remained under colonial rule, as France and Britain held on to distant possessions and subjects. In tiny Mauritius, the British governor, Sir Hilary Rudolph Robert Blood, remained happily ensconced as he wrote home, "In my pocket handkerchief paradise." In 1960, in Cape Town, Harold Macmillan evoked a wind of change, as 16 African countries joined the United Nations in a single year. As he did so, a British diplomat at the United Nations complained bitterly that decolonization was being used for the wrong reasons. It was based, he wrote back to London, on emotion, not on reason, and it was a form of colour prejudice in reverse. It reflected, in the words of this diplomat, a totally unjustified resentment of the darker peoples against the past domination of the world by European nations. That's a direct quote. In the autumn of 1960, self-determination reached the UN General Assembly. On December the 14th, 89 countries voted in favour of a resolution known as 1514. No countries voted against it, although 9 did abstain, including Britain and the United States, worried about setting in stone the idea of self-determination as a legally binding right. Resolution 1514 declared explicitly that all peoples have the right to self-determination, and it prohibited the partial or total disruption of the territorial integrity of any colony prior to its being given independence. The diplomat who presided over the General Assembly that moment was an Irishman called Frederick Bowen. He welcomed warmly the adoption. He was, in a sense, its handmaiden. And he, of course, had personal experience of British colonial generosity, having grown up in Dublin. The Assembly may well congratulate itself on this accomplishment, he declared as he brought down the gavel. His daughter, who was a young girl at the time, lived with him in New York. She became a world-renowned poet, Irish, in fact, one of Seamus Heaney's best friends. One of her poems, called Witness, begins as follows. What is a colony, if not the brutal truth that when we speak, the graves open and the dead walk? As the right of self-determination came into being, the people of Mauritius urged Britain to give them independence. And at this very moment, the United States here in DC was developing a new policy, one that placed military bases on distant atolls. Now, a word about Mauritius. The Treaty of Paris, signed in May 1814, ended the Napoleonic Wars, prohibited the international trade in enslaved people, and ceded various French colonies to Britain. One of them was called Ile-de-France. The British called it Mauritius. It came with dependencies, and one of those dependencies was the Chagos archipelago, about 2,000 kilometers away from Mauritius, actually closer to the Maldives. 58 islands and atolls, and a vast, vast ocean. The islands included one called Diego Garcia, and far to the north, another called Perros Banhos. Both islands produced large amounts of copra oil, plantation. By the early 1960s, as self-determination was being written into international law, Chagos had about 2,000 inhabitants, many of whom worked for the Société Huilière de Diego y Perros. They were all descendants of the original enslaved inhabitants. Many of them came originally from Mozambique. Britain resisted recognizing the independence of Mauritius because it wanted something in return. Secretly, it had acceded to an American request to make the island of Diego Garcia available to it on a 70-year lease as a communications facility. The British decided they would empty the whole of the Chagos archipelago of its population, just remove all of the inhabitants. We can do this, a Whitehall memorandum concluded, but we have to avoid the charge that we're trafficking in colonial territory, or that somehow we are disregarding the interests of the inhabitants, or creating, even worse, a new colony. So ever inventive, British civil servants and lawyers, with the help of their friends here in DC, sought to circumvent international law and Resolution 1514. We can detach Chagos from Mauritius either by securing the consent of the Mauritians or simply presenting them with a fait accompli. But it has to be done as rapidly as possible. That is Prime Minister Harold Wilson speaking. and it has to be done in utmost secrecy to avoid any scrutiny of what is happening. The Mauritians totally opposed the detachment of a part of their territory. They were invited to London to discuss independence. And on September the 23rd, 1965, Harold Wilson met the Mauritian leader, Mr. Ramgoolam, at 10 Downing Street. Wilson had with him a briefing paper which told him how he should deal with the Mauritians. And I quote, "The object is to frighten Mr. Ramgoolam with hope. Hope that he might get independence, fright lest he might not, unless he is sensible about the detachment of the Chagos archipelago. Diego Garcia can be detached unilaterally by order in council or with your agreement," Wilson told Ramgoolam. Under this intense pressure, an understanding was reached. In return for the detachment of Chagos, Mauritius would get its independence, a little compensation, some trade concessions, a few fishing rights around Chagos, and if the need for the facilities ever disappeared, the British agreed the islands would be returned to Mauritius. On the 24th of September 1965, Britain announced that Mauritius would gain its independence in 3 years' time. Behind the scenes, the colonial secretary paved the way forward. Present the UN with a fait accompli, bypass Parliament, adopt an order in council, detach Chagos, create a separate colony, and do it now. But there was one remaining problem. What are we going to do with all the human beings who live there? What will we do with the inhabitants? The British and the Americans agreed to proceed on the basis of a lie. They would tell the United Nations that there were no inhabitants. There was no permanent population. Everyone who lived there, whether they were 75 or 7 months old, was merely a contract labourer. They had no rights. The object of the exercise, a diplomat wrote in a secret message, which of course emerged in discovery many years later, is to get some rocks, and those will remain ours. So that Chagos becomes a place, he continued, and I apologise for the language that I'm about to use, a place with no indigenous population except seagulls, in which there would no longer be any Tarzans or Manfredas. The Privy Council passed its order in council and created a new British Indian Ocean Territory. All of Chagos, which was deleted from the constitution of Mauritius. A new commissioner was empowered to remove the entire population. In New York, the act prompted an instant reaction. The General Assembly passed a resolution expressing deep concern. It instructed Britain in terms not to violate the territorial integrity of Mauritius. Britain simply ignored the resolution and all the future resolutions that followed, which stated that disrupting the territorial integrity of Mauritius would be a violation of international law. Instead, Britain gave the United States a 70-year lease, and best of all, they wouldn't charge a single cent. It was a very generous British gift. In March 1968, Mauritius duly became independent, and a month later it joined the United Nations. Not long after, the Americans moved into Diego Garcia. The comedian, Mr. Bob Hope, visited on that first Christmas, accompanied by a troupe of 75 performers, including 32 American beauties, as he called them, and a lady, an Australian, who had recently been crowned Miss World. They met no one from the local community because by then everyone had been deported. Between 1968 and 1973, the entire population of the Chagos archipelago was removed, deported to Mauritius and the Seychelles, and some of them ended up in Britain, living in Crawley near Gatwick Airport, because that is where they were dumped. For several years, nothing much happened. Mauritius was coming to terms with new life as an independent country, dependent on Britain for sales of its only exports, sugar. And then in 1982, at the United Nations, the new Prime Minister of Mauritius, Sir Anirudh Jugnauth, finally, for the first time, called for the return of Chagos illegally detached. The Chagosians began to agitate. they litigated actively before the English courts, and with some success. In 1998, Olivier Bancoult, Lisby Elisé's nephew, won a ruling from the Court of Appeal that the deportations were illegal. Foreign Secretary Robin Cook agreed that the population could return to the outer islands, but not Diego Garcia. No interruption of the American base. And then came the events of September the 11th. The US base at Diego Garcia, as some of you will know, was used as part of the Bush administration's program of extraordinary rendition and the embrace of torture. And in March 2003, the bombing of Baghdad actually began with planes that flew from Diego Garcia. A year later, the British government reversed its decision to allow Madame Elysée and all the other Chagosians to return to Peros Banhos and the other outer islands. This caused significant protests in Port-Louis, the capital of Mauritius, the British High Commissioner being greeted by Chagosians with placards and claims that Britain was perpetrating a crime against humanity. That was how matters remained for 7 years. Then, in 2010, a new British Foreign Secretary, Mr. David Miliband, announced that Britain would establish a vast marine protected area over Chagos, the entire area, a marine protected area to protect oceans and biodiversity and burnish Britain's green credentials. And, this was the real reason, of course, cast a somewhat more favourable light on Chagos than its use in relation to the war in Iraq and the war on terror. In the area, all fishing would be banned, and so would all human activity except the hole at the centre of the donut, the US military base. And, of course, people with large yachts would be able to visit. The world's coverage of protected oceans would be doubled. It was a massive protected area. Britain takes its international environmental responsibilities seriously, Mr. Miliband declared. Conservation groups, particularly in Britain and the United States, were completely delighted. The renowned Zoological Society of London, of David Attenborough fame, and the Chagos Conservation Trust, and the Pew Charitable Trust, amongst many others, declared the announcement to be a historic victory for global ocean conservation. But these NGOs, and many of them were my friends, were totally silent about the effect on the Chagosians, who were, of course, deeply disturbed by the announcement on the use of the place where they were born and to which they wanted to return. The government of Mauritius was equally concerned, as Gordon Brown had, just a few months earlier, offered a private assurance to his Mauritian counterpart that Britain would not act unilaterally. And then, as Port-Louis pondered the options from Port-Louis' perspective, but probably not that of Washington, D.C., a minor miracle occurred. Something called WikiLeaks happened. WikiLeaks uploaded millions of pages of top-secret cables, and one was from the US Embassy in London to DC on the subject of the marine protected area. Mr. Colin Roberts, Director of Overseas Territories at Her Majesty's Foreign Office, extolled the virtues to the Americans of Mr. Miliband's plan to create the largest marine protected area in the whole world and to prohibit all human activity except, of course, on and around the US base at Diego Garcia, ! And, he added, wonder of wonders, the proposal will create no difficulties whatsoever for the local population because there is no local population. We do not regret the removal of the population, Mr. Roberts was reported to have told his American counterparts. There will be no human footprints. There will be no Man Fridays on the uninhabited islands of Chagos. This is 2009 in relation to this kind of language that is being used by a senior diplomat in the British Foreign Office. Pause and think about what that tells us about life in those departments in London. And, Mr. Roberts added, the marine park would forever put paid to the resettlement claims of the archipelago's former residents. Marvellous. Environmental protection harnessed to stop the Chagosians from returning forever. This was a document of the kind to stiffen the backbone. The Chagosians lodged a new case at the High Court in London to challenge the MPA on the grounds that its true purpose was actually to prevent the return of the Chagosians. The case would eventually be rejected, like others, by the Supreme Court, but not before it threw up in the process of discovery a raft of truly terrible internal government documents that shone a bright light on Britain's secret actions between 1963 and 1973. By now, also, KPMG, the accountancy group, was reporting that a return by the Chagosians was indeed feasible. Artisanal fishing, small coconut plots, and ecotourism could all provide jobs, and there'd be no adverse environmental effects. But despite the report that the British government had itself commissioned, it decided against resettlement for reasons of feasibility, defence, and national security. Mr. Miliband's announcement prompted Mauritius to reach out to the lawyers, and I was asked to lead a legal team to challenge Britain's actions under international law. The options were limited because the Foreign Office had closed off the possibility of Mauritius bringing a case directly to the International Court of Justice against the United Kingdom in a contentious case by excluding all such cases by members of the Commonwealth, or, if Mauritius left to bring a case, former members of the Commonwealth. So the paths chosen were limited to arbitration under the UN Convention on the Law of the Sea to obtain a ruling that the marine protected area was illegal. Illegal because Mauritius had never been consulted, and illegal because Mauritius, not the United Kingdom, was actually the coastal state, since the detachment in 1965 was illegal and without any effect. The path of justice is not a speedy one. 3 years of pleadings, then a hearing in Istanbul at the famous Pera Palace Hotel, where Agatha Christie wrote Murder on the Orient Express, and finally a judgment, March 2015. The 5 arbitrators ruled unanimously that the marine protected area was indeed unlawful because Mauritius had not been consulted. On the other hand, by a narrow majority of 3-2, the tribunal ruled that it could not exercise jurisdiction on the question of deciding which of the 2 countries was the coastal state, or on the legal effects of Resolution 1514 and its principle of territorial integrity. 2 arbitrators, however, dissented. They determined that the tribunal could and should have ruled that Mauritius was the coastal state, that it had not consented to detachment, and that Harold Wilson's frighten them with hope strategy amounted to duress, so that the creation of Britain's last colony was illegal and without effect. Now, this dissent was in the spirit of a great American jurist, Philippe Jessup, who had dissented, as many of you will know, in an amazingly important case called the Southwest Africa case, which ruled scandalously in 1966 by the smallest of majorities that Ethiopia and Liberia had no legal standing in international law to challenge South Africa's practice of apartheid and racial discrimination on its own colony of what was then called Southwest Africa, today Namibia. Read the only dissent Philip Jessup ever wrote. It's an extraordinary document. Judges Kateka and Wolfram, both judges of the International Tribunal for the Law of the Sea, were inspired by the spirit of that dissent, and their dissent opened a door. One of the things I've learned, this is for the students in the group, dissents are often very, very important in indicating the path of a future and more decent direction. This dissent by 2 judges caused the new Prime Minister of Mauritius, who happened to be Sir Anirudh Jugnauth, again on his 3rd time in office, to ask the lawyers, is there a route to The Hague? Is there a route to the International Court of Justice to the United Nations principal judicial organ, known by many as the World Court. There was, but only one route. The ICJ, as many of you know, can give an advisory opinion to the UN General Assembly. In 2010, we, the lawyers who were advising Mauritius, me, James Crawford, Paul Reichler, advised against this option because we thought it was totally unlikely that tiny Mauritius could persuade a majority of the UN members to vote against the wishes of the United Kingdom and the United States, two permanent members of the Security Council. But now circumstances have changed, not least since two arbitrators found in favour of Mauritius. And at this point, a second minor miracle occurred from the perspective of Port-Louis, not, I should say, from my perspective as a citizen of the United Kingdom. Britain, in its wisdom, voted to leave the European Union. As British ministers waxed lyrically about a new Empire 2.0 and alliances with Commonwealth countries, completely delusional in the view of many people, Britain's international authority fell off a cliff. The subject of Chagos, astonishingly, made it onto the agenda of the UN General Assembly. Extremely inventive and adept Mauritian permanent representative called Jagdish Kunjal was responsible for that. Bereft of any help from its former EU partners, who simply washed their hands of the whole thing and said, it's your problem now, not ours. In June 2017, the General Assembly debated a draft resolution to request an ICJ advisory opinion. A draft text, I should say, in which I'm not the only person in the room who had a hand in drafting what was, it turned out, a rather decent text. That draft was supported by all 54 members of the group of African states. We were told the first time that had ever happened in UN history, and also by the non-aligned movement. I flew from London to New York to lobby with the Mauritian team as Britain and the US warned that the UN was being used inappropriately, that a backdoor route to the court was being created. I spent many hours seated at a small table in the Indonesia lounge at UN headquarters, eating delegates one by one from dozens of countries. Some were my former students. Over a full day, only 2 delegates out of about 40 that I met, a genial Australian and a rather sensitive Canadian, expressed any support for Britain, but they did so with obviously little enthusiasm. Many delegates evoked Britain's continuing colonial instinct, patronising, entitled, hubristic. I learned a lot that day. I learned about the great gap that exists between how Britain sees itself in the world and how the rest of the world sees Britain. I learned what it means when your authority and power collapses. I saw eyebrows raised at the name being mentioned of the new British Foreign Secretary, Mr. Boris Johnson, who wrote articles for a newspaper called the Daily Telegraph, whose readers greatly enjoyed his racist epithets. One article, again, I apologise for the language that I'm using, referred to the inhabitants of Africa as pickaninnies with watermelon smiles. Such words may go down very well with the readers of the Daily Telegraph. They do not go down well with diplomats at the United Nations, nor did his racially charged put-down of President Obama, which was widely known by delegates at the United Nations. With the vote, the UN General Assembly's membership board lit up. Green in favour, red against, yellow for abstention, black for absent. Resolution 71292 passed with a huge majority. 94 countries in favour, just 16 against, and 65 abstentions, including China, Russia, and France. Only 2 members of the EU voted in support of Britain and the United States. Just 3 of the 54 members of the Commonwealth. Not a single country from Africa, Latin America, or the Caribbean supported Britain or the United States. Global Britain was being pronounced to us back home, it felt, sitting in that room, more like Little Britain. The General Assembly sent 2 questions to the International Court. 1, had decolonization been lawfully completed given the detachment of Chagos? And 2, if not, what are the legal consequences? In September 2018, the case was heard at the court. The first person to address the court was Sir Anirudh Jugnauth, the last survivor of the Lancaster House Conference in 1965. And it was on that first morning that the judges watched Madame Lisby Elisé's statement on video. And she sat in court in the front row, watching them, watching her. Britain argued that the court should not exercise its jurisdiction, and that in any event the detachment was perfectly lawful. The Chagossians, yes, the manner of their removal was shameful and wrong, the British Solicitor General argued, but not the fact that it occurred. Madame Elisé's words were very moving, he said, and he expressed deep respect to the Chagossians, but that was it, nothing more. No commitment to right the wrong, no concession on a return. Compensation was paid, that was amends enough. 23 countries spoke. The US and the UK were supported by just 2, Australia and Israel. But the rest of the world, every continent, supported Mauritius. South Africa spoke with a particular authority, as 5 decades earlier it had taken the position now being articulated by Britain in respect of its then illegal occupation of Namibia. As a former colony, counsel for South Africa told the court, we know all about colonialism and deportations and their continuing effects. And we know what it means when entire communities are taken from their homes on the basis of race. There is no such thing as part freedom, she concluded. Decolonization can never be partial. The line was inspired by Mandela, whose bust, coincidentally, stood on a pedestal outside the Great Hall of Justice. The court delivered its verdict in February 2019. It had jurisdiction, and there were no reasons not to exercise it. It had all the facts it needed. The questions were indeed about decolonization, and it was not a bilateral territorial dispute about sovereignty, as Britain and the US argued. On the merits, the facts were clear. The British and the Americans discussed, an agreement was reached, Chagos was detached, independence followed, the Chagossians were forcibly removed. Was decolonization completed? No, it was not. Resolution 1514 reflected international law at that moment in 1965, and it prohibited the disruption of the territorial integrity of a country without its consent. Did Mauritius give its consent? No, it did not. Paragraph 172 of the court's verdict is crucial. Having reviewed the circumstances in which the Council of Ministers of the Colony of Mauritius agreed in principle to the detachment of Chagos on the basis of the Lancaster House Agreement, the court considers that this detachment was not based on the free and genuine expression of the will of the people concerned. Pause for a moment. When I gave a version of this lecture in Dublin a few months ago, as you can imagine, this paragraph would have had a particular resonance in relation to an exactly analogous agreement that was reached in 1921 in respect of the 6 provinces that became Northern Ireland. It's an identical situation. There is a playbook here. The detachment of Chagos, the court said, was not based on the free and genuine expression of the will of the people concerned. And that meant all of the people of Mauritius and the people of Chagos. It followed that the detachment was unlawful, that a new colony was created, that the decolonization of Mauritius was incomplete. And the court turned to the consequences. Britain's occupation of Chagos is illegal, and the continued administration is a wrongful act. Britain must end its administration as rapidly as possible. Chagos is part of Mauritius, not the UK. The court passed the baton to the General Assembly, including on the matter of the future of the Chagossians. Only one judge dissented, wonderful judge, Joan Donoghue, American judge, but she did so not on the merits. She did so explicitly on the issue of jurisdiction, something she was very clear to point out. Not a single judge supported the position of the United Kingdom or the United States on the merits. 3 months later, the matter returned to the General Assembly, which adopted Resolution 73-295, which implemented and gave effect to the court's advisory opinion. Chagos is an integral part of Mauritius, the resolution determined, and Britain was ordered to withdraw its colonial administration within 6 months by November 2019. The Chagosians must be able to resettle as a matter of urgency. The UN, its members, the specialised agencies must now all ignore the existence of the so-called British Indian Ocean Territory and any steps taken by the United Kingdom in relation to that illegal entity. This resolution got an even bigger majority. Support rose to 116 countries, and those voting against fell from 16 to just 4 countries supporting the United Kingdom and the United States. Israel, the Maldives, Australia, and Hungary. Embarrassing, reported the New York Times. The British ambassador offered a last word. Depleted, crumpled, apparently tearful, she sort of dissembled. Britain remained firmly committed to self-determination, she declared on obvious instructions from London. Paused. She wasn't talking about Mauritius. She was talking about the Falkland Islands. No sovereignty until the Falkland Islanders want it, she said to the Assembly. It was an intensely awkward moment because many people in the room understood her to be evoking, in effect, one rule for the whites and another rule for the blacks. It was not a fine moment. What happened next? The advisory opinion and the resolution came in the dying days of Theresa May's government. They landed in the inbox of Foreign Secretary Jeremy Hunt. Whitehall insiders offered, the Brits, I mean, this is just it's painful. It's painful. It's painful. Whitehall insiders offered 2 options. The realists proposed that Britain, the US, and Mauritius should sit down and sort the matter out on the basis of the advisory opinion. Government may not like the advisory opinion, but it was what it was. Britain would have to live with it. It said it was committed to the rule of law in international relations. And in any event, Mauritius had made crystal clear for years that the US base at Diego Garcia would continue unimpeded. But the fundamentalists, led by the National Security Advisor in the UK, pushed back. Chagos is so indispensable to our national security that we must just ignore the ruling, hunker down, and carry on as though nothing has happened. And that was the view that prevailed. The British government just rejected the court decision. They said it's not binding on us, and the Chagosians will not be allowed to return. That approach made Britain an illegal occupier of the territory of Mauritius, just as South Africa was in relation to Namibia after the ICJ's advisory opinion of 1971. So was that the end of the matter? It was not. The advisory opinion has legal effects for the United Nations and its specialised agencies. The UN immediately changed its own official map of the world, which now showed Chagos as part of Mauritius. The Food and Agriculture Organization, specialised agency, said that it no longer recognised Britain's claim to fish around the Indian Ocean and the coastal state as Chagos because it wasn't the coastal state. Even worse for the British, who are a nation of stamp lovers, the Universal Postal Union notified Britain, horror of horrors, that it would no longer distribute any letter that bore a postage stamp issued by, and I quote, the territory formerly known as the British Indian Ocean Territory. And it got worse and worse. The International Tribunal for the Law of the Sea in Hamburg ruled in a dispute between Mauritius and the Maldives that the ICJ advisory opinion was authoritative, that Chagos was part of Mauritius, and that the marine boundary between Chagos and the Maldives was to be delimited between Mauritius and the Maldives, not the Maldives and Britain. And next week, on the 28th of April, ITLOS in Hamburg will tell us where that maritime boundary is drawn. Britain's reaction was sort of Alice in Wonderland. It just said, we're going to bury our head in the sand. And we're just going to hope that this wretched problem goes away. After the ITLOS judgment, a minister at the Ministry of Defence, not, I note, the Ministry of Foreign Affairs, not the Foreign and Commonwealth Office, who refused to say what the Ministry of Defence was about to say, adopted what was, for any international lawyer in Britain, one of the most surprising moments ever. He said in Parliament, "We have no doubt whatsoever about our sovereignty. We can draw our own maritime boundary with the Maldives." I mean, yes, I know, it's literally incredible. At this point, it's worth mentioning that 28 international judges and arbitrators have now had an opportunity to express their views on this matter. Not a single one has expressed any support for the British position. Across the world, of course, as in this room, there is sort of incredulity. What happened to the country that invented the rule of law, as it likes to argue? I'm often asked that question. What happened to respect for international institutions? To be sure, the position on Chagos has been part of a bigger picture, one in which the government of the United Kingdom treats judges and lawyers with contempt, sees international law as an inconvenience, and believes that international agreements, this happily has now changed in recent weeks, like the Northern Ireland Protocol to the Brexit withdrawal agreement, can just be torn up at will. A big price has been paid by Britain for all these actions. Trust and credibility have been shot. The world, as we know, is a small place these days. Beijing and Moscow laugh, Europe weeps, others just feel embarrassed. In the US too, there is a particular difficulty. President Biden has, of course, referred to the rule of law as one of America's most cherished democratic values, a riposte to the Trump administration, and a very useful stick with which to beat China in relation to the South China Seas and Russia in relation to Ukraine. Secretary of State Antony Blinken has castigated Beijing for making unlawful maritime claims in the South China Seas, for ignoring law of the sea rulings, which I know well. I was counsel for the Philippines in the case which found against China, so I'm well aware of China's approach. But the Biden-Blinken position of principle seems somehow less forceful in relation to Britain and the Chagos archipelago. One act of lawlessness does not justify another. If you're going to weaponize the rule of law, you have to be sure that your own house is in order. A civilization that plays fast and loose with its principles is a dying civilization, Aimé Césaire wrote in his discourse on colonialism. The British government is not alone in its state of wonderland. Private businesses too have turned a blind eye. There's a company in Guernsey owned by a Bahraini outfit called Shaw, which continues to offer telecom services to those who live on Bayat and to mariners in the vicinity. If you're a football supporter, soccer fan in this country, many of you will recognise the hoardings on your TV screens for a company called sportsbet.io. What does IO stand for? IO stands for Indian Ocean, and it is a name, domain name, which is nominally assigned to the British Indian Ocean Territory. It is incredibly popular with high-tech companies, and it is extremely costly to get, much more than others. Someone is making very significant sums of money out of this act of illegality. The tiny Pobjoy Mint in Surrey, southern England, continues to issue and sell Biot coins. The Zoological Society of London, until very recently, patron Her Majesty the Queen, is rightly proud of its conservation work in Chagos, but it too has just ignored, until recently, all the international ruling. Until very recently, its website proclaimed that Chagos was a part of Britain and it was fully entitled to carry out the work that it was doing. Such conservation work is, of course, hugely important and deserves full support if it's being done lawfully, with the authorization of Mauritius. But it's not. Britain is in illegal occupation of Chagos, with companies like Shaw and Sportsbet.io and the ZSL supporting activities that prevent Madame Élysée and the other Chagossians from being able to return to the homes from which they were forcibly removed 5 decades ago. Perhaps those engaged in authorizing or engaging in these activities may want to reflect on their association with such international illegality and on the human consequences of continuing to support the existing status quo. Let us not forget that international law has long treated forcible deportation without lawful cause as an international crime. As I described in East-West Street, when Hirsch Lauterpacht put the concept of crimes against humanity into the Nuremberg Statute in the summer of 1945 and into international law, where it resides still today, in its Article 6, Paragraph C, he and Robert Jackson, the chief prosecutor, introduced the word deportation as a crime against humanity, the forcible transfer of a group from one territory to another. The 1948 Universal Declaration on Human Rights recognizes that each of us has the right to return to our country. The 1949 Geneva Convention explicitly prohibits the forcible transfer of individuals or groups or their deportation from one territory to another. And of course, as you all know, Article 7 of the Statute of the International Criminal Court, adopted in 1998, defines a crime against humanity as including the deportation or the forcible transfer of a population. And it is this very provision that has been invoked by the ICC prosecutor to issue the first indictment by the International Criminal Court in relation to the current situation in Ukraine against Mr. Putin and the Child Commissioner for the deportation of a large number of children, apparently from Ukraine to Russia. Indeed, a month ago, Human Rights Watch issued a report which characterized the mistreatment of the Chagossians historically and still today by refusing to allow them to go back as a crime against humanity. That is, we understand, the first time that the United States or the United Kingdom have ever been accused of a crime against humanity by Human Rights Watch. So what's to be done? There's a reasonable and clear solution, one that respects the intertwined issues: the territorial integrity of Mauritius, the rights of the Chagossians, the protection of the environment, and matters of national security. Mauritius, Britain, and the US have close and excellent relations, and India can play a significant role. The sovereignty of Mauritius over Chagos is clear and now recognized under international law. Mauritius, as I mentioned, has supported the continuation of the US base at Diego Garcia. It has offered the United States a long, long lease, one that will provide long-term security that lacks under the current arrangement. Mauritius has declared that the creation of a lawful marine conservation area for the whole of Chagos will continue, and that it would like to work with British government, scientists, and organisations like the Zoological Society of London, Pew, and others. Which leaves the Chagossians, who are the beating heart of this story. They are a large group. I first got to know them more than a decade ago. Many individuals with different views and aspirations. Some want to return to the outer islands of Chagos, including Peros Banhos, or to work at the US base at Diego Garcia, alongside the many other nationals who work there today. The outer islands sustained human habitation for more than 2 centuries, and they can continue to do so. KPMG, the accountancy group, has made that clear. And the islands are very far from Diego Garcia. It cannot be said they pose a security threat to Diego Garcia. Writing for the majority in one of the cases brought by Olivier Bancoult before the Supreme Court in London, Lord Hoffman, one of the justices, made clear that the contrary view that somehow allowing the Chagossians to return to the islands would create a threat of terrorism was merely fanciful speculation. There is a win-win-win outcome. Security, human rights, the marine environment, and respect for sovereignty and territorial integrity can all be assured. The rule of law, treaties, UNCLOS can all be promoted, and the charges of double standards and hypocrisy can be cast to the wind. This is not a zero-sum game. And that's the reason that I wrote the book, The Last Colony, which will be published in the US only in September of this year, to ensure that any Chagossian who wants to return to Chagos and to Mauritius can do so, and to encourage Britain to lower its flag on the last colony in Africa. The alternative simply undermines Britain and undermines the United States. It undermines the ability to challenge the manifest lawlessness of others. It will promote the view that Britain and its friend remain imbued or supportive of a colonial instinct. And now, finally, after so many years, there is, after this interminable struggle that has gone on for 5 decades, signs that change are in the air. A year ago, last February, in the context of the case to delimit the maritime boundary between Mauritius and the Maldives, Mauritius organised, for the first time in its history, a site visit to its own islands, to the Chagos archipelago. We gathered at the dock of Mahe Port in Seychelles on the Indian Ocean. We were 25 in number, Mauritian government officials, marine scientists, journalists, lawyers, academics, and of course, Madame Lesbie Élysée and 4 of her friends from Chagos. Olivier, her nephew, Marcel, her childhood friend, the fisherman from Ile du Coin, Rosamund, who spent her first 17 years on Salomon Island, and Suzelle, who was forcibly removed from Diego Garcia as a contract labourer aged 11 months. We sailed on a ship called the Bleu de Nil. It was a journey of 1,000 miles. It took 6 days to get there. We spent 5 days there and 6 days to come back. This was, as I said, the first ever visit by Mauritius to its own territory. It was the first time any Chagossians had been to the islands without a British armed escort. It was the first time any journalists were allowed to cover it. I recommend in particular a wonderful article by Colin Murphy in the Atlantic magazine, which has been published very recently. It was my first time there. After 5 days at sea, the boat approached Perros-Bagnols, and we all were able to see the place of Lesbie Élysée's birth, the sandy fringe, the palm trees of Ile du Coin, the reefs, the waves, the birds. The anchor was lowered. Lesbie pointed to the place of her birth. She had a huge smile and her eyes danced. She was the first on the island, and as she got off the little boat that deposited there, she bent to touch the water and pick up a handful of the fine white sand. Olivier sank to his knees. A religious community, the very first thing they did was to stand together in prayer, holding hands as the rest of us wept. There was immediately work to be done. Within the hour, they were in the church, cleaning it up, and then off to the cemetery to clean the gravestones that had been there for more than 2 centuries. Nature had crushed colonial civilization, but they were not going to be stopped. On the beach, Lesbie Élysée perched on a long, thin, sturdy trunk of an old palm that had fallen across the sand and hung over the blue water. She bounced up and down on it, like when I was a child, she said, speaking in Creole, her language. She danced to the rhythm of her favourite songs, Perros Vert and Grand-Maman Chagosien, in harmony with Olivier, Marcel, Suzelle, and Rosamund. And later, as we headed back, sitting on the deck of the boat, she and Marcel reminisced about childhood on Perros-Bagnols, playing hide and seek between the palms. Marcel, he hasn't changed at all since then, she said. He's busy, busy, busy. And what was Lesbie like when she was a child? I asked Marcel. He offered his magical, mellow grin, one that infused his whole face, and he said, exactly the same, round, round, round. He laughed, he stood up, puffed out his body, stooped and waddle bounced away, and we all roared with laughter. And then he went over to Lesbie and pressed his fingers on her forehead. It was as though a whole lifetime of affection could be felt in a single touch. 6 months after we got back, something cracked. Amazingly, we're able to give credit to Prime Minister Liz Truss, who in her extraordinarily short tenure of 49 days, nevertheless managed to do one excellent thing. She, who had been Foreign Secretary, realised that Britain's position was utterly unsustainable, that it was time to change tack and to recognise the new realities. And so, just after she left office, but in the words of the same Foreign Minister, Mr. Cleverly, on November the 3rd, in a written answer in Parliament, he announced a 180-degree change of position. Britain would now negotiate with Mauritius on the exercise of sovereignty on the basis of international law. And those negotiations are now underway. But the question is, what really, really caused the change? And that brings us to Ukraine. You may ask yourself, what on earth has this got to do with Ukraine? This is what it has to do with Ukraine. You will have noticed that over the past year, support of many countries from the global south in relation to a position that I strongly support of Britain, the United States, and European countries, Australia and others, is barely supported by the global south. Barely. What is going on? What is going on is best understood if you speak to African ministers or South American leaders or Asian prime ministers or presidents. And I've spoken to quite a few of them. Interesting, they say. The Brits come along and talk to us and try to persuade us to help them support Ukraine in its efforts to end the Russian occupation of large parts of Ukraine. That's interesting, we say to them. Aren't you occupying a part of Africa? What is the basis on which you ask us to do that when you yourselves are failing to respect international law in relation to matters of self-determination, occupation, and decolonization? If any of you have spent time in Ukraine since the war began, you will hear many Ukrainians, as I have, I've been a couple of times since the war began, talk about the Russian effort as a colonial effort. For people in Ukraine, it is an exercise of colonial power. That is what has caused the United Kingdom to change position. It's not a fundamental commitment to principle. It's a reflection of a decrease in authority and in power, coupled with a manifest double standard. That double standard has been made even more complex by the great elephant in the Ukrainian room, which I've noticed from the time I've spent in the United States over the past year is less of an elephant than it is in Britain and Europe, and even less of an elephant in relation to any other part of the world, and that is Iraq. It is not often said in the United States that Iraq was a manifestly illegal war. It was. I draw no distinction between the decision to go to war in Iraq and the decision to go to war in Ukraine in relation to Russia. Mr. Putin has used the very same arguments that Britain and the United States marshalled in 2003. We cannot tolerate having weapons of mass destruction in certain places aimed at us. That war has not only armed Mr. Putin with his appalling use of force in relation to Ukraine, but it has completely undermined the ability of Britain and the United States to speak with any real authority in relation to the crime of aggression that is manifestly taking place. Of course, there is a difference between the purposes that motivated the war in Iraq and the purposes that appear to motivate Mr. Putin today. But if you go back to the basic instruments, the UN Charter, the rules of customary international law, it's very hard to find a difference. And what I find right now actively involved in relation to the efforts to address the crime of aggression in relation to Iraq is, in Ukraine, is Iraq thrown back in my face every single time I raise it in a country outside the Western powers. We need, I suppose, in some way, to come to terms with our own double standards. Chagos is a story about double standards. Sure, it's on a tiny scale compared to some of the other stories. But the essence of it is that if we're going to conquer the world with our commitment to issues of principle and to the idea of the rule of law, we've got to either avoid a double standard or be honest about it when it happens. These issues are interconnected. The world is changing. If you go and speak to places in other parts of the world, for example, in relation to Chagos, you will see why 54 African countries have united on that issue to get the British out of part of illegally occupied Africa. And that is the reason that there is almost no support amongst African countries in relation to Ukraine. I regret it deeply. I am foursquare behind the British and American positions in relation to Ukraine. But I recognize the almost overwhelming difficulties those two countries face in persuading others in the face of our own recent history and our own continuing history in relation to the Chagos archipelago. I can judge by the silence in this room that there is a difficulty in coming to terms with some of what I've said, particularly in relation to what happened in 2003. We have to come together and find a way to deal with what happened in 2003. There's been no reckoning. There's been a sort of quasi-accounting in the United Kingdom with the Chilcot Inquiry, which went very, very far. But to my deepest regret, the British Prime Minister of the time declined to accept the findings of the Chilcot Inquiry and on what had gone wrong in Iraq. And in the United States, as I understand, there has been no accounting in relation to Iraq. And so long as there is no honest accounting in relation to that issue, so long as there's no real engagement with the reality of what's going on at Chagos and Diego Garcia, we can't expect the rest of the world either to join with us or to just keel over when we come to them and seek their assistance in relation to something we really care about. It's a deeply interconnected world. And that, in a sense, is what is so emblematic for me about the story of the Chagos archipelago, and even more so, the story of a single determined lady who cannot read, who cannot write, but who has spent 50 years trying to get justice done and is now on the cusp of going back to the Chagos archipelago. Let me stop there. Thank you very much for your attention.